Welcome to our session on digital ecosystems. This webinar is part of the academic program of the 58th Annual Congress of AIJA with the overall theme, United in Diversity, Empowering Our Future. This panel is organized by the Antitrust, Trade and IP TMT Commissions, and I thank General Reporter Gustavo Papeschi and our three speakers, Luciana Martorano, Florencia Rosati, and Sven Price, that we are here today to discuss this highly interesting and actual topic. My name is Sophie Gilliam. I'm a senior associate with DLA Piper and president of the Antitrust Commission. I will be moderating the session, and I'm very pleased to introduce you to the three speakers today. But before I do so, first a couple of practical remarks with regard to this session. This session was pre-recorded earlier this month, so please excuse us if you miss the very latest developments, as these follow in a rapid pace. We will try to make up in the live Q&A that will follow the presentations. Benefits of this pre-recording is that I don't need to ask you to put your microphones on mute. And also you will know that at 4:45 sharp, we will start the live Q&A. Only at that time, the Q&A function will be opened. So please save your questions until then and submit them via the Q&A function to one or more of our speakers. Thanks. These are exciting times for all advising in the digital space. Online platforms, and even more so a digital ecosystem, whether that ecosystem is an app for everything or a family of apps, can be applauded for offering a prime customer journey and unprecedented opportunities. They are rewarded for their efforts with more users, more user attention, and sophisticated insights in customer behavior, also called big data. This in turn allows platform operators to further strengthen their position. Having a dominant position is in itself not prohibited, but the power that comes with such position calls for responsibility. The question is how to best tackle concerns. The three speakers will each address the topic from a different angle. Florencia Rosati, she's a partner with law firm Becker Varela in Argentina and co-heads the firm's intellectual property and TMT department. She's also a member of the Diversity and Inclusion Committee. Florencia will address the topic of liability of platforms that, being the middleman, have also own responsibilities. Next is Luciana Martorano, founding partner of the competition law boutique Martorano Law in Brazil. The question how to deal with global digital ecosystems under the existing competition law rules is dealt with by many competent authorities around the world. In the EU, the platform to business regulation is now applicable, and there is more to come. The European Commission's ongoing consultation on the Digital Services Act package also includes a new competition tool. And we learn what proposals will follow the recent big tech antitrust hearings in the US. In addition to the exploration of new tools, we also see new focus and theories of harm. In her contribution, Luciana will in particular address the interplay between competition law and data. The main case in this respect is the Facebook case in Germany. From Germany, we have Sven Price. I'm very pleased that he will complement this panel by providing us with an in-house perspective. His former lawyer and expert in copyright and media rights is since a couple of years head of legal at the German Scout24 group. Scout24 operates, amongst others, ImmoScout24, the market-leading platform for residential and commercial real estate in Germany. And the aim of Scout24 is to build a comprehensive ecosystem for real estate agents, home settlers, and consumers in Germany. Sven will share with us insights drawing on his first-hand experience of the Scout24 online platform and ecosystem. Now, we hope that you enjoyed this session and that you will leave with more knowledge on this topic and food for further discussions with market players and users, as this topic concerns us all. Now, Florencia will start, hand over to Luciana, or hand over to Sven. We will all be there for the live Q&A at the end of this session. Thanks. So, Florencia, the floor is yours.
Hello, everybody, and thank you, AIJA, for inviting me to join this wonderful panel where I will be speaking about digital platforms liability. To start with, digital platforms are online businesses that help the interaction between at least two different groups. One group is mainly comprised of suppliers, and the other group is mainly comprised of consumers. And there are different kinds of digital platforms, such as marketplaces, search engines, social media, streaming, collaborative, messaging, and others. And why does digital platforms liability matter? Perhaps it is because, according to Global Web Index, an average person between 16 and 64 years old spends 6 hours, 43 minutes per day on the internet. And what are we doing during those 6 hours, 43 minutes? If we take a look at Alexa's ranking on the world's most visited websites, we will see that the 21st positions are, most of them, if not all, digital platforms. Take a look at these highlights as an example. So having made this introduction, we will now talk about the developments in case law and regulation in the US, the EU, and Latin America, the reasons for rethinking liability regulations, and to conclude, the swinging of the love-hate pendulum of digital platforms. Let's start with the developments. As you surely know or can imagine, digital platforms liability was first discussed and regulated in the US, secondly in the EU, and only afterwards in Latin America. Let's see what happened in the US. In 1991, when there was still no express regulations on digital platforms liability, a district court in New York had to resolve the case of T.R.A.D.E. versus CompuServe. In this case, CompuServe was hosted an online forum, and the content was managed by a third party. T.R.A.D.E. found that some of that content was defamatory against them and sued CompuServe as the speaker or publisher of that content. The court, however, understood that even though CompuServe hosted the defamatory content, they couldn't be held liable because they acted more as a distributor than as a publisher of the content, since they did not moderate or in any way review the content that was hosted by this or uploaded by these users. In 1995, in the Stratton Oakmont versus Prodigy Services, the New York the New York Supreme Court of Justice resolved a similar case. In this case, Prodigy hosted a bulletin board whereby a user had uploaded defamatory content against the plaintiffs. The plaintiffs, again, considered that Prodigy should be held liable for this content, while Prodigy said that they shouldn't be held liable and relied on the doctrine of the T.R.A.D.E. versus CompuServe case. However, in this case, the New York Supreme Court understood that Prodigy was to be held liable since it monitored the content which was uploaded by the users, exercising an editorial activity or control, and as such, it should be held publisher of the content and consequently liable. As we see, even though Prodigy acted in good faith to moderate the content, it ended up being in a worse situation than CompuServe, who did nothing about the content posted by third parties. After these conflicting cases, in the year 1996, Section 230 of the Communications Decency Act was passed. This section provides immunity to internet services providers or online intermediaries for third-party content, providing that intermediaries cannot be considered the speakers or publishers of third-party content. It also provides immunity for internet services providers or intermediaries for good faith blocking or filtering of infringing content. This is known as the Good Samaritan Doctrine or rule and was passed as a consequence of the Prodigy case. In 1998, the Digital Millennium Copyright Act was passed, complementing this regime, and provided a safe harbor for ISPs for third-party content infringing intellectual property, provided certain conditions were complied with including notice and takedown obligations. In a nutshell, this safe harbor provides that ISPs won't be held liable provided they don't have effective knowledge of the illicit nature of the content and, once aware of it, act expeditiously to remove or block such content. Let's see what happened in the EU. 2 years after the Digital Millennium Copyright Act, in the year 2000, the e-commerce directive was approved. This e-commerce directive was also approved after conflicting case law and regulations in the member states of the EU and provided for a safe harbor for online intermediaries hosting or transmitting third-party content under certain conditions. Articles 12 to 14 classified intermediaries in 3 different categories: mere conduit, caching, and hosting providers. And it establishes that mere conduit providers will be exempted from liability provided they only passively transmit the message without initiating the transmission, without choosing the receivers, and without modifying or initiating the transmission. Caching providers will be exempted from liability provided they only temporarily and automatically host the content just to make the transmission more efficient. And hosting providers will be held liable only after they have effective knowledge of the infringing content and when they don't act expeditiously to remove it. The e-commerce directive also provides that there cannot be imposed a general obligation to monitor third-party content for online intermediaries. Unlike the Communications Decency Act in the US, the e-commerce directive does not provide for a Good Samaritan doctrine or clause. However, it does provide that filtering systems are admitted provided they are automated. Duties of care are imposed on online intermediaries, including notice and takedown obligations, and self-regulation is encouraged. This e-commerce directive is also complemented by sector-specific regulations such as the Directive on Sexual Abuse Online, the one on hate speech and violence, the one on copyright in the digital single market, and the regulation on platform to business. Let's go to the case law in the EU. I have made a selection of 5 cases decided by the Court of Justice of the EU. The first of these cases is L'Oréal versus eBay. In this case, the court made a distinction between the active or passive role assumed by the marketplace. And the holding of the case is that marketplaces or other online intermediaries cannot rely on the hosting exception to liability provided in the e-commerce directive if they have assumed an active role in the promotion or sale of the goods, or if they have been aware of facts or circumstances that have made them realize of the unlawful nature of the offer, and they have not acted expeditiously to remove it. The second case, it's a set of 2 cases really. It's Scarlett Extended versus Sabam and Sabam versus Netlog. In these cases, Sabam is an author association and Scarlett Extended is a hosting provider and Netlog is a social network provider. And it was decided that this hosting provider and social network provider cannot be obliged to keep on general filtering systems preventing the upload of content infringing copyright works protected by the authors of Sabam's association. The third or fourth case that I'm going to talk about is the Uber case. In this case, the Court of Justice had to decide or answer the question whether Uber provides an intermediary service or rather a transportation service. In this case, the court decided that Uber cannot be considered an intermediary and should be considered a transportation service or a service in the field of transport because it exercised decisive influence over the transport service provided by the drivers. Things that the court took into account was that the drivers couldn't provide the service in the absence of the platform, that Uber selected the drivers, and that Uber fixed at least the maximum fare for each of their trips. 2 years later, the same court, in the case of Airbnb, had to answer the same question, whether Airbnb was an intermediary service provider or whether it was an accommodation service provider. However, the same court, in this case, 2 years after the Uber case, resolved that Airbnb should be considered an intermediary case, an intermediary service, sorry. And for this, the court took into account that Airbnb did not exercise decisive influence over the service to be provided by the hosts. Why? Because it didn't control which were the hosts that were renting their apartments on the platform. It didn't control the prices, and it didn't control the guests. So what we learned from these two last cases is that depending on the degree of control that the platform has over the service to be provided via the platform, is the more or less chance of being considered an intermediary subject to the e-commerce directive and the limitation of liability provided therein. Let's see what happened in Latin America. Specifically in the case of Argentina, there's no express regulation regarding ISP's liability. There have been several bills that have been introduced in Congress, but all of them lost parliamentary status, with the exception of one that has been introduced early this year, but has not been discussed yet. As regards case law in Argentina, it is mainly divided between cases involving search engines and cases involving marketplaces. In the case of search engines, we have a leading case, which is Rodriguez versus Google, which was decided by a Supreme Court in 2014. In 2014, our courts were still divided between those that considered that search engines had to be liable on a strict liability basis, and those that considered that the negligence-based standard should apply. Finally, the court considered that the negligence-based standard should apply, and the search engines would only be liable provided they have effective knowledge of the illicit content and don't act expeditiously to remove it, following EU precedents. As regards marketplaces, we have different precedents. These are only a few of them. And they also follow the EU precedents, establishing that provided they take an active role, they will be held liable, or when they have knowledge of the content. If they act passively, they won't be liable. So, it's about time to rethink digital platforms' liability regulations, which are at least 20 years old. And the reasons to rethink this is that some think that digital platforms have assumed a more active role, in many cases being at least curators of the content provided by third parties. They also say that they are interfering in political life, and for this we can think about the Cambridge Analytica case and the impact of it. They also say to remain passive before the proliferation of fake news and hate speech, not to mention competition and privacy issues that will be addressed by Luciana and Sven later. So, to conclude, it appears that we have a swinging pendulum that's moving back and forth to love and hate against digital platforms. When they first appeared in our lives, we fell in love at first sight with them. We considered that they were intermediaries that had to be protected against secondary liability so that they could continue operating and we could take advantage of the services and products that they offer. After the Cambridge Analytica scandal, we demonized digital platforms and even fantasized with ceasing using them. Nowadays, in times of COVID, I think that we may all agree that digital platforms have made our lives easier. We have all been able to work from home, to pay our bills remotely, to order our groceries, even entertain ourselves with music streaming or movie streaming. And we have kept in touch with our family, friends, colleagues, clients, and even have been able to attend online conferences like this. So maybe we should reach a balance, take online platforms for what they are, review periodically their liability standards, but when doing so, act unemotionally and dispassionately. Thank you very much.
Thank you, Florencia. Hello, everybody. It's a pleasure to be here today. I would like to thank you, AIJA, for the kind invitation. And as Sophie has introduced, I will talk a little bit about data protection and antitrust. Well, my name is Luciana Martorano. I'm from Brazil. I'm an antitrust lawyer. And I would like to start this brief panel with the following question. Is there real interplay between data protection and antitrust? Well, the answer for this question seems to be yes, in accordance with all the cases involving these matters around the world. Besides the numerous theoretical arguments involving the debate, the antitrust authorities around the world have found some way, somehow, a connection between these two topics. And it doesn't mean, however, that must be a mandatory issue to competition in the markets, but that privacy policies could be considered from a competition standpoint whenever they can affect competition, and notably when they are implemented by a dominant player. Well, in general terms, there are four main theories that try to attach privacy to antitrust issues. The first one is the mergers between companies that hold big data. It is one of the biggest issues that antitrust authorities around the world have been addressing and have been concerning about it. And in general lines, the antitrust authorities believe that mergers between companies that hold big data might increase their joint data boot and making the resulting company even more powerful to profile individuals and invade consumer privacies. This is because, of course, all we know that the big tech companies hold a lot of data and personal, even sensitive personal data related to all of us. And of course, they make use of this data to enhance their products and to make their platforms even more interesting for us. The second competition harm theory is related to network effects. And the antitrust authorities believe that the network effects can create market barriers to new entrants, because of course, with all the big data at their disposal, they can have more inputs to produce better services and better platforms. And on the other hand, the new entrants would have to make a lot of time to create this big data, right? And also the antitrust authorities believe that the network effects can decrease the incumbents' incentives to compete to offer better goods, such as privacy-friendly services. Because once the consumer is attached to this digital platform, it cannot open hand from using it anymore. It is used to it, and then it gives up of his or her own privacy in order to keep using the platform. And we are all into it every day. As just Florencia has just said, we are more into this mainly now that we are in the middle of a pandemic. The third theory of harm is related to the quality of products and services. In relation to this theory, the antitrust authorities believe that depending on the way that the consumer welfare has to an antitrust regime, the quality of products and services may be assessed by taking into consideration whether they are privacy friendly or not. And of course, in relation to this topic, it will depend on the way that the antitrust authority and the competition policy of such country give or not importance to privacy in the whole system, right? Of course, we know that in the European Union, we have more rigorous laws protecting data. We have a general data protection laws, the GDPR, as well as we have here in Latin America. A lot of the countries in Latin America, I believe all of them have general data protection laws. And we don't have the same reality in the US. Of course, they have very important data protection laws, such the California Act, the Consumer Act, the Teenagers and Kids Protection Acts, but they don't have yet a general data protection law. So of course, the weight on this matter will depend on the general legislation of each country, right? And antitrust authorities may wonder in relation to the consumer welfare that goods or services are not privacy friendly and are low quality goods when they invade the individual's privacy. And as a consequence, any practice, for example, a merger, unilateral behavior, agreement, goods, which are not privacy friendly, could harm consumer welfare, and as such must be held anti-competitive. The fourth and last theory of harm that I would like to address in here is related to data protection as an abuse of dominance. The antitrust authorities believe that it takes place when a player violates individual data protection guarantees by abusing of its market power. And here we can, of course, mention the Facebook case in which the social media imposed some terms and conditions for user data collection in violation of data protection laws. Sven will explain the case in detail for you in the sequence. It's a very interesting case, and for sure, so far it's the most important one in terms of investigation and in terms of result. And I would like to address some brief conclusions. Of course, the topic is yet very incipient around the world. We don't have a lot of cases to base on to try to get some objective conclusions. As Florencia has just mentioned, we have some interesting cases in the US, the EU, and in Latin America. Particularly in Brazil, we still don't have a specific case to mention. But I believe that in general lines, the interplay between data protection and antitrust law is important and can help the authority to identify anti-competitive practices. However, it can only take place when falling within the scope of competition law, what is not true for all antitrust legislations around the world. It is also important to check whether the antitrust regulator is allowed, in accordance with its institutional and legal competences, to address data protection issues without crossing its competence line. And this is true mainly here in Brazil. Our antitrust authority, the Administrative Council for Economic Defense, CADE, does not have institutional competence to address specific matters regarding data protection and to point liability to digital platforms. It should be treated by the judiciary so far, because we also do not have any specific institution to address digital platforms, liabilities, and matters. So it will, of course, depend on the legislation that we are analyzing. And a general rule, antitrust law does not intervene on market features and structures. Antitrust, I believe, is a tool to deal with structural competition problems and not to regulate the markets. And I believe in most of the liberal economies around the world, this should be true. I would like to finish my brief introduction regarding the interplay between data privacy and antitrust by letting you all with two personal observations. First, that is that it's a thought, actually, that if digital platforms do not have enough incentives to produce privacy-friendly services, this is a matter for governmental and economic regulation and not for antitrust law. We have to, of course, antitrust is very important, and we are all inserted in a competition frame, but we have to take a lot of care to not think that antitrust can solve all problems of the world. I believe this is a tendency in a lot of jurisdictions. In Brazil, we have this tendency that the super CADE, the super antitrust authority, should address all the interdisciplinary issues involving antitrust. But wait, we have to think about the antitrust authority competencies and the limits that it will be able to address, right? And second, I believe that one thing is certain by analyzing all the cases that we have around the world that have already faced the interplay between these two very important topics. There is not so far an antitrust threshold defining when privacy violation occurs in the context of anti-competitive investigations. So we don't have a proxy. We don't have nothing, basically, to even try to begin to investigate markets and to lead us to a line to do this investigation and this analysis. We have to address case by case, and of course, observing the legislation and the institutional context of each country and of each antitrust law, right? Well, this is all for now, and it was a pleasure to be here today. Thank you all for watching, and I will give floor now to Sven.
Thank you, Luciana. We would prepare here to hand over, and I will start my screen sharing here as well. Let me give it here. There we are. So thank you very much to Luciana and Florencia for paving the floor with lots of general and very important questions. What I can do from an in-house perspective is to show you a practical view, what it means to be a market leader and how we have to deal with the competition law and antitrust. And as I'm from Germany, I can tell you something about the case, the Facebook case that we already mentioned before. First of all, thanks to AIJA, thanks to T.R.A.D.E, the Antitrust, and the TMT Commission for being part of this brilliant panel. And now with the start, I think you are eager to hear what happened there. It's not a fairy tale, but I can say most recently in Germany, because it's pretty fresh, is that there was an injunction imposed from the Federal Cartel Office to Facebook. What happened? They made a major investigations into what Facebook is, whether they are market leader or not, and what are they doing with the data, with the personal data of their users. And they found out that Facebook is connecting and combining the data of its users with lots of other data outside of the Facebook world. And if you want to be part of Facebook, you have to accept their terms and conditions and allow them to do so. This is something that the Federal Cartel Office said, well, we can't allow this anymore. This is a violation of data protection. This is also abusing market dominance position. So they put up an injunction on Facebook to use its terms and conditions. And Facebook went to court, and for the higher regional court of Düsseldorf, which is the first instance regarding cartel proceedings, they said, well, this can be an abuse of dominance, but you, the Federal Cartel Office, would not be allowed to impose injunctions such as this based on data protection. This is competition law, not data protection law. And then the Federal Cartel Office went to the Federal High Court, and remarkably, because most of us thought it would be like the higher court of Düsseldorf would prevail, said, no, it's like that. Facebook has a clearly dominating position on the social media market. This is very remarkable because they made a major investigations into that and say, well, they even say there's no doubt that they are dominating the social media market. And second one is that they're exploiting the user and its personal data so that it's abusing it. So the injunction was upheld, and Facebook can't use right now the terms and conditions as it did before. The last word is not spoken here in the proceedings because it's only the injunction proceeding. The main case is still pending at the High Court of Düsseldorf, and I'm very sure that it will go to the Federal High Court as well again. So we'll see what happens, but this is like the most recent news where Facebook is facing the Federal Cartel Office injunction in Germany. This is very remarkable, as I said, because it's one of the first ones in that broad sense and in the EU. So even before the US, usually it starts in the US, then comes EU, then Latin America, as we heard before from Florencia. This is the first time that we come first, and we'll see what happens. And maybe it's precedents for the US as well. We will see. So this would be highly appreciated to follow up on this, what happens there, and how Facebook and how the court reacts. This is the most recent update on the Facebook case, bringing into the data protection issue. What I can tell you right now is something that I'm an in-house lawyer at the Scout24 group, as Sophie already introduced. And we are a market leader. So from our perspective, diversity is something that we are not very keen on because we want to be market leader and we want to stay market leader and maybe want to even make it make our position even better than before. What is ImmoScout exactly? It's a website, it's an online portal, and there you can put up your real estate listings. Say you want to sell your house, you want to sell your apartment, or you went to rent an apartment. So you go on our website and there it's listed. There you can see what is on the market. And then you can contact the owner, you can contact the real estate agent, whoever is taken care of. And we started 20 years ago, and we disrupted the market when disrupting was not even a word. And we put the advertising, which was in the papers, online, and now everything's online. And we were there first, and that's why we are market leader here. We are the #1 in Germany. We are also big in Austria. with our portal. And in Germany, we have about 60% share in online listings. Some years ago, the Federal Cartel Office was investigating the market and said it is the online listing market that we have to look at. And that's why we have a clear market leader position. So we have to think of competition law all the time. Our two main competitors are the Immowelt Group and eBay Classifieds. As you may have heard of, is that eBay Classifieds was sold 2 or 3 weeks ago for like 9 billion euros. Lots of money there. So we will see whether eBay would be a more hard competitor in the future or not, but we'll see. But these are the two ones that we have to take care of the most in our market. And now we come to the question of the overall topic, diversity, but also ecosystem and market leadership. Two main questions from a practical point of view, which I am asking myself and my business is asking me whether we are allowed to do this, would be, can we have exclusivity with our consumers, with our agents, with all of our customers? Is it possible that we keep them exclusively on our platform? Because we are market leader anyway, you don't have to go to somewhere else. This would be something. And the second one would be, how can we do the price adjustments? Like, can we give them rebates? Can we excel the price? Whatever we want to do, do we have to be careful? Quite clear answers. Exclusivity contracts for a market leader, as we are quite a problematic topic. So what we have thought of is that we don't use exclusivity, but we say, well, there is some multi-homing going on. What is multi-homing? It is that people are listing on our platform and on eBay and on Immowelt as well. This is a quite common topic and common practice in the world of online platforms. You want to spread everything. So, and then we said, yeah, we don't say exclusively, but you have to be first at ours. So in the first 7 days, you go on our platform and put it here. And after that, you can go wherever you want. So that is something that is not exclusivity, but that's something that we can tell our customers that, you're first here, so we can give you a little bit of rebate because you are preferring our platform. We always have to look at that quite closely. Why? The real estate market in Germany is pretty hot. So when you want to buy something, you have to be quick. If you want to rent something, you have to be even quicker. So 1 week listing first could be that it is actual in exclusivity. And so we really have to look at the data all the time, whether we're still in there and whether we can do it like that, or if we have to adjust even the timelines and timeframes. This is something that we look at closely every day, because we can't do exclusivity contracts as our market competitors can do, because they are not the market leaders. So when my business comes to me and says, we want to keep the people here, yes, you can, but as a market leader, we have to look at the competition law. Second would be the price adjustments. It's not something that we can't do as the exclusivity ones, but there's always a but. We have to be careful how we do this. There are two things, the two major things. One would be increasing the prices. When you're the market leader and people would know that 60% of the listings are at our platform, consumers might tend to go only to our platform. So that's what everybody knows. So I think, okay, I go to the market leader. Then I said, as a market leader, okay, then I can make up the prices because the people come anyways. This is something that we really have to take care of and closely look at, whether we're still in a range that we are not too high in the prices, because we are using and abusing our dominance position, because they have to come to us anyway. So you have to accept the price, take it or leave it. This is something that we can't do. We really have to look at the pricing. We have our own department for this, who's doing all the time doing the math. and whether we are still in the market or not, or whether we are too expensive or even less expensive. We'll see. It depends on the product. And the second one would be about giving rebates, giving discounts, pulling the customers from the other contracts, from the other competitors to us, and giving them rebates, giving them lots of discounts, and saying, yeah, please come to us, and then you get 100% off. This is also something that we can't do. We really have to look at that we don't disturb the other competitors to be still on the market. So, and we also, what we are aiming for is the digital ecosystem for the real estate. We want to keep the people on our platform, and all of them. As you can see the circle here, and we want to build an ecosystem where you can make your transfer, your buying of an apartment totally digital on our platform. This would be great for us, but it's also something that we really have to look at the competitor side, the consumer side, the customer side, whether we are not abusing our market position. And this is what we really looking at, and we really have to be careful, but it's something that we want to do because we think it's good, as Luciana and Florencia already said, that in times of COVID, digital is good, but we really have to be careful not to be anti-competitive. So to wrap it up in very nicely colored diversity bullet points, we see that the German Federal Cartel Office increases the pressure on online platforms like us. So we really have to be careful. Competition law joins forces with the GDPR and the data protection. So it intervenes, and as we can see from the Facebook case, is that it was already held as an argument for anti-competitive use. And there will be coming up a new regulation on so-called supermarket leaders, such as Facebook, Google, Microsoft as well, where they are with a law that they are held to be liable for certain actions that they should stop. One would be that they should not combine personal data with other data, as we saw in the cases, and also is that they would say that they are not allowed to use its market powers on one market to go swiftly to another market and block the competitors there. And this is something that will come up in the new regulations, maybe later this year. And it's also EU-wide, so competition law is getting stronger also on the platforms. And to make the circle, back to Florencia, in case of any abuse or damages you may face, you can go to Florencia and ask her, because she explained it brilliantly. So thank you very much for listening. And now the Q&A comes up, and we are eager to hear your live questions. Goodbye.